this evening, what we're going to look at is how the Supreme Court judgment has impacted on individual policies over that have been rejected in the past, and what can be done and what applications can be made moving forward to try and make sure that payouts are made under the insurance policies. We're also going to look at, many of you may be involved in the CQC challenge, and we're going to have a look at how business interruption insurance will affect any other claims that you may have that are ongoing. If I could ask everyone to turn their videos off, if I could ask Mark Ems, sorry, we can see you, to turn your video off, that would be really helpful. And then we'll start moving forward with the webinar at this stage. So at this moment, if I can hand over to Laura Pearce. Laura is a solicitor at JFH Law. She is a senior solicitor. She has a lot of experience of dealing with business interruption insurance and other insurance claims. She's been looking at these policies throughout the pandemic, looking to try and see if people can make claims, assisting people in making claims. So she really does know everything about these policies. I'll hand over to Laura now. Over to you, Laura.
Yeah, thank you. Good evening, everyone. I won't go through that. Julia's just been through that. There's where you can find us on social media if you haven't already connected with us. We're on all of the big ones. So today, yeah, as Julia said, we're going to go through the Supreme Court's decision in relation to the FCA's test case for business interruption insurance. Now, there was the High Court judgment, and that was quite a big win for policyholders. But the Supreme Court actually went a bit further in a number of areas, which is really good for policyholders as well. So just a bit of a background. I mean, as we all know, it was the 30th of January last year when there was declared an outbreak, a public emergency by the World Health Organization. 31st of January, so just over a year ago, we had our first 2 positive cases. On the 5th of March, the government put COVID as a notifiable disease within their health protection regulations. On the 16th of March, the Prime Minister gave the message for people to stay at home. At that point, he hadn't said to any businesses to shut. He'd just given the message for people to stay at home. On the 20th of March is when he actually said, no, now we're going to close pubs, restaurants, gyms, leisure centres, things like that. And on the 21st of March, regulations were put in place to put into effect those closures. It was around that time that obviously people started making claims on their insurance policies, and we saw a number of clients have their claims rejected straight out. You know, some of the insurers were even saying, don't even bother putting in a claim. We're not gonna give any consideration to it. The FCA were obviously very concerned about the number of insurers that were rejecting claims. And so they proposed under legislation to have a test case. And 8 of the insurers agreed to be part of this test case. And on the 1st of June, a framework agreement was signed in relation to this. The 9th of June, the FCA issued their proceedings in line with that agreement. And on the 20th of July, the High Court hearing began. The 15th of September is when we had that High Court judgment. And as I said, it was pretty favourable for policyholders in the first instance. The FCA and the insurers both put in appeals in relation to that judgment. The appeals leapfrogged to the Supreme Court so that it can be heard quickly because of the serious nature of this. The 16th of November is when the Supreme Court hears all of the evidence, and on the 15th of January, the Supreme Court handed down its decision. So as I said, today we're going to go through the main areas of that judgment. So what the effect it has on disease clauses, what effect it has on prevention from access and hybrid clauses, what trend clauses are and how that could affect the policy, what the claims process is, and then Julia will give an update on the CQC legal challenge towards the end. So starting off with disease clauses. So these are clauses which provide cover for business interruption losses resulting from the occurrence of a notifiable disease at or within a specified distance of the premises. So this is what a disease clause looks like. I think this one's from the RSA policies. So it's an occurrence of a notifiable disease, and that is normally defined within the policy, at the premises, or an occurrence of a notifiable disease within a radius of 25 miles. Now that radius can change. So I've seen policies with 1 mile, 5 miles and 25 miles. So it will depend on what your policy says as to what the radius is. Some policies just say the premises themselves and don't have any radius. So that's all important in determining whether you've got cover and how that will affect your claim. So the Supreme Court was asked to, in relation to these clauses, answer 2 questions. So first of all, what is the insured peril? And what is the link between that peril and the business interruption? Now, in the appeal, the insurers were trying to argue that any case of COVID that occurred within the geographical area did not cause the business to close. It was because of the sheer volume of COVID cases outside the area that the businesses were closing. The lower court found that there was just one, the pandemic was the insured peril, so they didn't have to talk about the link. They just said, well, actually, no, that can't be right. We're going to say the pandemic is the insured peril and therefore losses are covered. Now, the Supreme Court, whilst finding in favour of policyholders, what they said is that the insured peril is each case of COVID at the premises or within the specified area within the policy. So each case of COVID is what we're looking at in relation to whether or not you've got cover. So if there's a case of COVID at your premises or within the specified area, then you've got the insured peril. And in terms of the link between the case of COVID and you shutting, what the court said is that, well, you have to bear in mind what the parties' expectations are. And the purpose of the government restrictions is to stop infectious disease spreading quickly. So it's going to be obvious that the government is going to put in place restrictions to stop the spread. So there is a link between each case of COVID within the area and the business interruption, namely the restrictions placed on businesses to shut because of the pandemic. So like I say, this is a really good result for policyholders, because if you can show that you've got this case of COVID at the premises or within the specified area, then you should have cover under your policy according to the Supreme Court judgment. But what evidence do you need to show? So what the Supreme Court said, the insurers were trying to argue, well, you'll need to have an actual diagnosis in order to get the cover. And the Supreme Court said, no, that's just not feasible. And that's not what these policies were designed for. So again, this is a really good point for policyholders because you don't need to show an actual diagnosis. It's likely to fall on the balance of probabilities. So depending on where you are, you might be more likely to show that you've had a case of COVID. For example, if you're within the London area, you're definitely going to be able to say there was a case of COVID. But if you're on the Isle of Sicily, then that might be a bit different. There might not have been many cases there. So it's going to turn on the balance of probabilities. However, saying that, if you can show that there's been an actual diagnosis, then obviously you're home and dry on that evidential point. You might know someone that was diagnosed with it. You might be able to look on the Office of National Statistics and get an idea of how many cases were in your area. So in relation to this, just to give you an idea, when the insurers were trying to argue that you needed an actual diagnosis, the FCA produced a map of London, of the UK, and they did a 25-mile radius. And as you can see on this, just as an example, 25 miles from a point in London is a massive area. And their point was that, well, it's going to be easy for someone to show that there's been a COVID case because the 25 miles is such a large area. And actually, there's only you only need a few circles to cover the whole of the UK. So like I say, this is a good, for anyone that's got a disease clause, this is a good win. So the next question is, because some of these policies, as I said, you've got to show that there was a notifiable disease. And you have to look at the policy wording to determine what a notifiable disease is. And there are different definitions of this in different policies. So I've seen a few different policies and even you all have even slight differences in them. The ones before the Supreme Court were this. So what they said is that any human infectious or human contagious disease, excluding AIDS or an AIDS-related condition, an outbreak of which a competent local authority has stipulated shall be notified to them. So the minute that COVID became a notifiable disease in the regulations, it fit into this definition. So if your policy has this definition, then yours is a notifiable disease within the policy wording. However, we have seen some policies that provide a list of diseases. So they'll set out a number of different diseases that are covered. Some of them just list them and that's it. Some of them go on to say an outbreak of which the competent local authority has stipulated shall be notified to them. Now, we have some concerns as to whether or not if you've got a list in your policy, you'll be able to claim. And the reason being is that a lot of the lists don't contain SARS. And as we know, SARS has been around since 2003 to 2004. So it's been specifically excluded on purpose from policies. It is a notifiable disease, but the insurers have decided not to put it in their insurance policies. And that could be a really important point when coming to claim on your insurance. Now, unfortunately, it wasn't felt, I don't know why, for the Supreme Court to determine this point, because this is, like I say, a pretty major point in some of the policies. But it didn't fall to the Supreme Court to determine this. So in our view, if you've got a list and SARS isn't in it, without the wording on that or something similar in your policy, then you might not be able to claim. If you've got a list with that wording, then you might have a better chance, because this wording kind of says an outbreak of which must be notified. And obviously, as we know, on the 5th of March, it did become a notifiable disease. So the Supreme Court's decision was very much in favour of policyholders and saying, well, you're small businesses, you're not expected to have legal knowledge. What are your expectations? So I think there is an arguable point to say, well, my expectation is that if it says it's going to be stipulated to the local or notified to the local authority, then when new cases come in that are on those regulations, I expect them to be in my policy. So I think there is an argument there on that side of things. But like I say, if it's just a list without SARS, I think you might have more of a struggle with the insurer. I would still have the argument, because it's, you know, you're just going to them and you may be able to put in a case to the Financial Ombudsman Service, which I'll come on to later, which is a free complaint service. So it might be worth your time and effort to do it. But like I say, it's not as strong as argument as others, I think, within this Supreme Court decision. So one of the other things that insurers were trying to argue in relation to disease clauses, and I have seen this in some of the policies I've reviewed as well, is in the far end of the document. So you have your business insurance, say at page 10, and at page 40, 50, 60, you've got some general exclusions. And these general exclusions are supposed to apply to all of the rest of the clauses. And in some of them, like I say, I've seen this, it says cover's not provided if it's as a result of an epidemic. Now, like I say, the Supreme Court was really in favour of policyholders, and they said that the insurer cannot rely on these types of exclusions if they're buried in the contract. So if they are buried towards the end, where, like I say, you wouldn't necessarily know that it refers to this, the insurer it's tough. So that's good news for policyholders. So what that means is that unless there's the exclusion in the section, in the business interruption section, the insurer is unlikely to be able to rely on it because it's buried away. And like I say, small businesses don't have legal knowledge. They're not expected to know the law, to know what, you know, legal words mean, that the fact that there's an exclusion at the back, it refers to things at the front. So the Supreme Court very much found in favour on this. So that's another good win for policyholders. So if your insurer tries to say, well, there's a general exclusion way at the back we're going to rely on, you can refer to the Supreme Court case and say, no, you're not going to be able to do that because you're limiting my liability and I didn't know about it. So like I say, another good win on that point. So the next type of clauses are what's called prevention from access, hybrid clauses. So a prevention from access clause in general is one that provides business interruption losses resulting from public authority intervention, preventing or hindering your access to your business premises. And a hybrid clause is the prevention from access clause, but also has a disease element to it. So I'll show you some examples. So this is a pure prevention from access clause. Losses resulting from prevention of access to the premises due to the actions or advice of a government or local authority due to an emergency which is likely to endanger life. And then these are the hybrid clauses, so a blend of both the prevention from access and the disease. So these say losses resulting solely and directly from an interruption to your activities caused by your inability to use the insured premises due to restrictions imposed by a public authority during the period of the insurance following an occurrence of a human infectious or human contagious disease, an outbreak of which must be notified to the local authority. So what the court said in relation to these clauses is that you'll see there I put A, B, C, D. And what the court said, and this is what was used in the judgment, this kind of A, B, C, D, is that you had to show each element in order to bring a claim. So you had to show where there is a disease, where's the hybrid clause? You had to show the occurrence of COVID within the specified area. And then for both types of hybrid and the prevention from access, you needed to show that there were restrictions imposed by a public authority that caused an inability to use your premises, that caused an interruption to your business. So that's what insurers are now going to be looking at, that flow chart, when they look to see whether or not you've got cover under your claim. So if we go through what these mean in reality. So with the disease element, so a notifiable disease within a specified area, it's the same test as I said for the disease clauses. So you just need to show that on the balance, there was a case of COVID within the geographical area that's within the policy. So that again, may be the premises themselves, it may be a 1 mile, it may be 5 miles, or it may be 25 miles. Now, a couple of the policies that were before the Supreme Court, they had no geographical area whatsoever. So they just said an outbreak of a notifiable disease. The insurers tried to argue that, well, that couldn't have mean a pandemic, it must mean something local. And the Supreme Court were quick to say, well, no, that's rubbish. If you wanted a restriction, you should have put it in there. And it was actually one of the insurers that had restrictions in other policies. So the court said, well, you know full well how to put a restriction in, you chose not to. So it's the entire UK, basically. So the next part of the flowchart is restrictions imposed by a public authority. Now, the first part, does the restriction need to have the force of law? So is there a legal requirement? So as I said at the start, on the 21st of March, the government put in place regulations that said businesses had to close. And the lower court found that those those regulations were when kind of the restrictions came into effect. That was when the restrictions were, and that you had to have the force of law behind the restrictions in order for them to be classed as restrictions by a public authority for the purposes of your insurance. Now, the Supreme Court said, no, that's not correct. So this was another win for policyholders. What the Supreme Court said is that it's a restriction it doesn't have to have the force of law. It just has to be that the policyholder had an expectation that perhaps a law was going to follow, or that they knew that they had to comply with it to such an extent that, you know, it could result later on in issues happening to their business. What the court said, it's unrealistic to expect policyholders to examine the legality of an instruction direction to close coming from a public authority before deciding whether to close and knowing what to do. So again, the Supreme Court was very much in favour of policyholders, saying you're not meant to know what is legal, what is not legal, who has the authority to give me these instructions. If you're told to do something, can you go ahead and do it? Then you should be covered by your policy, is basically what the Supreme Court was saying. The example they gave is if a public health officer discovers vermin in a restaurant and issues the restaurant to close, instructions to close immediately, that at that point is not a force of law, but something would come later down the line. And one would expect that restaurant to close straight away on receipt of those instructions. So this is good news for dental practices, because what this means is that the CQC's instructions to close are going to be an instruction for you to close, even if they didn't have a force of law behind them. You felt that you had to close or risk being inspected, losing your registration. So in our view, the CQC's instruction would fit into this. It would be a restriction by a public authority. Now, one thing we've been looking at, and Julia's going to talk a bit more about the CQC challenge, is whether there's any evidential issues with this, because as we all know, or as some of you that have seen our webinars on the CQC legal challenge, the CQC are now saying that they never gave an instruction to close. What the CQC are now saying is that it was, well, we thought that you should follow the advice, but ultimately it was up to dental practices whether or not to close. Now, we have seen, and I'm sure you have seen the emails from the CQC from the 25th of March onwards, and the very first one uses the word must. And I think that that is enough for the court to say, well, those words must give an indication that the CQC is saying you have to close. So even if that instruction was wrong, we still think the insurer should be covering your policy as a result of these clauses, these prevention from access clauses. Like I say, if the insurers tried to say, well, the CQC never gave that instruction, I think you can rely on those initial communication from the CQC. They said you must close, and I think given the judgment that you're not expected to know what's, go through it with a fine-tooth comb and understand the legalities, I think that is enough for you to rely on in relation to this. The court then had to determine whether the restriction needed to be imposed directly on the policyholder or whether indirect instructions, for example, the message to stay at home, the message that you could only go out for certain reasons, whether that was enough. Now, for our purposes, this isn't really an issue because the CQC's instructions were directed at you, were directed at dental practices. So you had this directly, you were directly told to shut. But even if you weren't, what the Supreme Court said is actually it can be indirect instructions. So if the fact that a shopping centre is closed because they have to, and your business is within that, then that is likely to be, an indirect result of the closure. So yeah, again, the Supreme Court was really on the side of policyholders in relation to this, saying it can be direct or indirect instructions. So is the CQC a public authority? Well, we obviously think they are because we were going to judicially review their initial decision to tell dental practices to close. The questions are things like, does it carry out public functions? Well, yes, it does. Was it set up due to an act of Parliament? It was. And as I said, can you judicially review it? The only caveat I've put at the bottom there is with everything, every policy is a different contract and it will depend on what your wording says, because I have seen a policy that says the medical officer's decision. So that might change whether or not you would have cover, because the CQC is not a medical officer. And there might be other restrictions within the policy. So just check the wording. But generally speaking, if yours says that you have got that there are restrictions imposed by a public authority, then you should have cover under your policy. So inability to use, this is the next point that you have to determine. So you have to show that there was an inability to use the premises. Now, the lower court found that the policyholder would have to show a complete inability to use the premises, so that they couldn't use it for anything. So the example that was in the Supreme Court decision is the fact that restaurants might have a takeaway service as well as a dining service. And the lower court's finding meant that the fact that they could still use the takeaway service meant that they had no claim whatsoever. So even though they might have lost a lot of business from not being able to use their dining, that was tough in the lower court's opinion. And again, this was another win for policyholders, because the Supreme Court said, well, no, that can't be right. It's the inability to use it for the purpose that it's designed for. So again, with the example of the restaurant, what the Supreme Court said is, well, that restaurant can claim for the losses suffered as a result of not being able to use its dining, even though it can still run a takeaway service. The other example they gave is a bookshop that might have 80% sales through footfall, but 20% online. In those circumstances, the bookshop will be able to claim for the 80% footfall that it has lost as a result of having to close its business. So like I say, this is another good win for policyholders, and this might help some practices if you're a mixed practice, because what I consider this means that you can separate the two practices out, the two businesses out. You can say that we've got the mix, we've got an NHS practice and we've got a private practice. And if you can show that you had an inability to use your private practice and that resulted in losses, then you might have a claim for that, even though you were receiving NHS payments. So that might be handy for mixed practices, that decision. Another win for policyholders is that the court found, like I said, it didn't have to be a complete cessation of the business. So this is, like I say, a win for policyholders and helpful for dental practices that are mixed. One thing that was looked at, because dental practices could stay open under the regulations, and it was just initially private practices, it was just initially the CQC's instructions that made a lot of private practices shut. One of the questions for the Supreme Court was, well, what about my, say, reduction in people coming in because they're staying at home more? Would I be able to claim for that? Is that an inability to use? And the Supreme Court unfortunately said that a mere interference is not going to be enough. That's not going to be an inability to use. So if you just have generally found that less people are coming in because they're being told to stay at home, then unfortunately you won't be able to claim for that as per the Supreme Court's ruling. So trend clauses. So trend clauses, they allow for trends during the indemnity period to be taken into account when assessing loss. So this isn't about whether or not you've got cover. So if you're able to get over the hurdle to say, yes, I've got cover under my policy, the insurers can then look at what's called these trend clauses to determine whether they can reduce your losses in any way during the period of indemnity. And this was another area that the court was asked to look at, because the insurers are obviously going to be trying to use these in order to reduce your losses as much as they possibly can, because I think it's reported that as a result of the Supreme Court's decision, insurers are going to have to pay out about £1.8 billion in cover for claims. So this is something to look out for in your policies, because like I say, the insurers may use these to knock you down. So these are some examples of when there may be a reduction as a result of a trends clause. So if you're a business that's slowly been suffering a loss year on year, so you've had a 20% reduction in profits year on year, then the insurer can carry on and make a 20% deduction from your losses, because what they would say is, well, if it was a steady 20% or whatever average it is, we're going to take that off, because it's likely that that would have continued throughout this period if there had been no pandemic. The other example given was a restaurant that had to close due to COVID, but actually was about to lose its famous chef that had a draw. And it was that famous chef that meant that people were coming and the restaurant was booked out. If the insurer can show that it was that the famous chef that was actually the draw and he was going, then they might be able to reduce the losses in relation to that. I suppose just thinking about it, one thing that could be is if you've got a highly renowned specialist in your practice that was due to leave, whether that would have any effect on your policy and the insurer being able to reduce your losses. Oh, yeah. So some points that the insurers are trying to argue that I've heard about. I've heard that one insurer is trying to argue that a restaurant that actually had increased business once it reopened, because obviously everyone was going out, they were trying to argue, well, that is mitigation, what's called mitigation. So we can take that increase into account and we can reduce your losses because of that increase in footfall. In our opinion, that's not going to wash. Your indemnity period is the date that you closed to the date that you reopened. So that is the period of loss that the insurers should be looking at. And anything after should not be taken into account in relation to if you've had an increase thereafter. It's the period of loss, that's the period of indemnity that's being covered. So that's where your losses are. Do you need to repay furlough? Because obviously if you have got coronavirus job retention scheme and you've received payments under that, that is kind of a type of mitigation that you've received to help reduce your losses. It will depend on your policy wording. Our view is that you probably don't have to repay it. You just have to take it into account when you're assessing your loss, that you don't have that loss of you didn't have to pay that out. You were able to get government funding for that. That might be the same for a COVID business interruption loan. Again, you'd have to look at the wording of your policy to see what it says about losses. Another question is, and this hasn't yet applied to dental practices, because once you were allowed to reopen, that's been it. You've been allowed to stay open throughout. But what if in the future you're asked to close again? Will you be able to bring another claim for that interruption? Again, it will depend on the policy wording, because you'll have limits on the indemnity period. So some say 3 months, some say 6 months, some say 12 months, some say 24 months. So if you got 3 months in your policy, but you were closed for 4, you will only be able to claim for 3. A lot of policies also have limits on the amounts you can claim. So you might have lost, say, 50,000 in the first closure, and say another 20,000 in another, but you might have a limit of 40,000 and you'd only ever be able to claim for that. The other thing to look out for is whether your policy says about reoccurring events, and whether it says, well, actually, you can only claim once for this type of claim. You can't claim if it happens again in the future, or it might say you can't claim, if it's reoccurring within 6 months. So just look out for those types of wording. It would depend where they are in the policy, because there might be issues with the insurer having to, like I said about the general exclusion, if they're hidden away, but just look out for these types of wordings just in case. So the claims process. So if you do now think that you've got cover, what should you do? So contact your insurer and lodge the claim. If you haven't already done so, you'll need to check whether there are any limits about notifications, because some policies say you have to notify them as soon as reasonably practicable within a certain period. So whether the insurers will, like I say, because there are going to be massive amounts of money that they're going to have to pay out, whether they are going to be really strict with time reporting. So just have a look for that. But if you haven't already done so, contact your insurer and lodge a claim with them. If you have and your claim's been rejected or partially rejected, and you think, well, actually, they shouldn't have rejected that part of my claim, you've got to exhaust the insurer's complaints procedure first. So ask for full written reasons for the rejection, so you can deal with all points in your response, and ask for a copy of the complaints procedure so you know what the process is, so that you can follow it to the T and make sure you've gone through the whole process. In terms of the next step, if the insurer still rejects your claim and still says, no, we're not going to pay out, you can go to the Financial Ombudsman Service to make a complaint to them. You can only do so if you're a small business, and a small business is defined as an annual turnover of less than 1 million. So as long as you don't meet that, as long as you're under 1 million turnover, you can make a complaint to the Financial Ombudsman. You must make the complaint within 6 months of the final rejection. Now, if you've already had a rejection and gone through the complaints procedure, but now think the Supreme Court judgment helps you, I'd suggest writing to the insurer, setting out why you think that the Supreme Court judgment helps you, and asking them to reconsider their decision. And if they still reject it, go from 6 months from that rejection. In relation to this, the 6-month time limit, it is quite strict, but the financial ombudsman do allow extensions in exceptional circumstances, and I think this will be one of them, because until the 15th of January decision, we didn't know what was going to happen. A couple of things to note with the financial ombudsman services: the maximum award is 350,000 plus interest, and you only get your legal costs in limited circumstances. So if you do instruct a lawyer to help you with that, you might not get your legal costs back. Is the decision binding? So if the financial ombudsman gives a decision and you accept it, then it becomes binding on you, and you can't then later change your mind. If you're not happy with it, then you can actually say, oh, I'm going to go to court. So you've still got the option of going to court thereafter. At any stage of those 3 steps, you can get a solicitor to help you. You may be able to get no win, no fee funding to help you with those steps. You may have another insurance policy that has legal expenses insurance that might cover a claim as well. So have a look at that. And then the final step is a court case. So if the financial ombudsman, or you're not happy with it, or you're over the 350,000 limit, then you can go and take your claim to the court. You've got 6 years from the date of the breach to issue, so it might be worth going to the financial ombudsman first, because like I say, you can reject their decision and still have the option to go to court. You're likely to get some of your costs back if you do go to court and are successful. There's also group litigation. So if there are a few of you with the same policy, you can look to help spread the costs. The only issue with court processes is they can take 12 to 24 months from issuing the claim to conclusion. And bear in mind as well, you've got to go through the pre-action process before you can issue. So it can be quite a lengthy process in order to pursue a claim. However, if you issue, you might get a settlement later down the line without having to go all of the way, because most claims do settle without the need for a hearing. And I think that's everything from me for now. Julia's now going to go through the CQC challenge.
Right. I'm going to try not to induce the same level of noisy yawns that Laura induced. Sorry, I'm not sure what happened there. Laura, perhaps if we can move to the next slide, yeah. Laura. I mean, I'm going to keep this very brief because a lot of you here won't be involved in the legal challenge against the CQC, but I know that some of you are. So I just wanted to cover very briefly what's happening there and how the BII issue may impact on the CQC legal challenge. Because of course, what's absolutely clear is that it is not possible to double recover here. So if you have a BII, a successful BII claim, then you would not be able to seek damages from the CQC for the unlawful closure of practices back in March 2020. So you'll see here the limitation deadline for the claim is the 24th of March 2021. So if anyone isn't signed up or wants to, you have to get involved now, because once that deadline passes, that is the end of your opportunity to be a party to the action. Now, what this is very relevant to is that people who have had their BII policies rejected or claims rejected, and I know unfortunately that does relate to a lot of practices, because I know that the BDA Lloyd and White policy is not paid out or paying out even after the Supreme Court judgment. Unfortunately, that is one of the policies that is not affected and is not helped when it comes to the Supreme Court judgment, which is a huge disappointment, I know, to many of you. So what this does is give you another opportunity to seek recovery of your losses for that period. But obviously be aware that you can't double cover, you must seek to mitigate your losses. So you must be shown that you have sought to obtain a payout under your BII policy if possible. So this is certainly very, very important for everyone. if you are someone who is involved in the CQC challenge or has a private element to your practice and lost funds as a result of the closure, then if you're not able to claim under BII, you can claim for the CQC challenge, but make sure that you have your name under both of them, if that makes sense. So if you are making a BII claim, do it now so that you don't miss the 24th of March deadline when you have the opportunity to do something else. Make sure that you have both bases covered if you think that there's a real risk that your BII policy isn't going to be paid out. I will be entirely frank, it is much, much better to claim under your business expenses insurance because there is no discretion when it comes to damages. So it's it's much more beneficial to the practice and to you, much less stressful to claim under the BII than it would be to go down the legal challenge route. So certainly do that first, but do get a move on because time is running out when it comes to CQC. I don't know if we can go to the next slide, Laura. Yeah, so if no BII cover or BII claim is unsuccessful, then we'll start the proceedings, or you should start proceedings against the CQC. What I would say is that we will be issuing our letter for action in the next week or so, next few weeks, that if there is going to be a delay, if there is a lot of people who are dealing with these claims, one of the things that we are going to ask the CQC to do is agree to a stay or a delay in the limitation period expiring to allow as many people as possible to seek cover or to seek payout under the BII policies. So that will hopefully buy us a little bit more time to make sure that everyone has absolutely maximised their possibility of success for BII. What I would say is if you are interested in the CQC challenge, then do get on board. There are, I saw a question come up, say, in the sense of, in the case of the CQC challenge being unsuccessful, would you be liable for the CQC's costs? Well, part of the CQC's claim is that we need numbers involved to make it viable, because one of the things that we are going to seek to do is to obtain both litigation funding and also after the event insurance. And that would cover the legal costs of the CQC. What we're trying to do is create as sort of low risk as possible to dental practices whilst maximising any damages that you may be entitled to. But as I say, as much as we love a fight, as much as we love litigation, I would much rather see you successfully claim under your insurance policies because it's quicker, it's more cost efficient, and if you've got a proper policy, you are guaranteed a payout, whereas you're not necessarily guaranteed a payout under the CQC challenge. So I hope that that is clear. Now, there have been, sorry, Laurie, do you want to move on to the next slide?
Yeah. Oh.
So that's the end of what I wanted to say there. There have been a multitude of questions coming up, and they're still coming up thick and fast. So what I'm going to do is take an opportunity just over the next sort of 10 minutes to run over a few of the points that have been raised with in the chat box, ask Laura a few of the questions and see if she can shed some light on them. Some of them I think have probably been answered as Laura has gone on. But one of the first questions was it would be helpful if there were a list of insurers that are offering cover as a result of the CQC, as a result of the Supreme Court decision. Now, I don't know whether you are able to clarify that, Laura, whether there are any that you know as a matter of fact will pay out. Obviously, I've already mentioned the ones that we certainly know at the moment are not paying out, and that's the BDA one.
So the FCA website obviously has the ones of all the policies that were part of the Supreme Court. I think there is also a little questionnaire on there as well to see whether your policy should pay out or not. But at the minute, I'm not aware of any specific list that's out there. I'm trying to think who paid out on one of mine recently. I can't remember off the top of my head, but I think we're just at the minute, I think people are still trying to put the claims in, and obviously the insurers are going to have a lot of claims being put in. So, you know, they might be taking time to go through them. So at the minute, we don't have a specific list of insurers that are and are not.
Do you have any that you know are definitely paying out?
I can't think off the top of my head the one that I know, but obviously the ones in the FCA case, so RSA was one of them. I think QBE was one of them. I can't think off the top of my head who the other were, but they are. If you go on the website, there's a list of all the ones that were part of the Supreme Court case and what their policy wording was.
And I think what we can probably do after this webinar, we will put a link to this recording onto our website, and we will include in that link a list of any that we do become aware of, we are aware as part of the policy that are paying out. One of the a number of things that have been raised, a number of questions raised in respect of who in fact told the dental practices to close. Now, it is pretty clear, and I can probably answer that one. Dental practices were not told to close by the GDC, even though they are a public body. They were initially told to close by the CDO, but of course that's in relation only to NHS practices, and it's the CQC who had the power to then close everyone, which is what they did following the direction of the CDO. They effectively adopted her policy. Now, there's also been a question that indemnity insurers also told a number of dentists that if they did practice, that they would not be provided with indemnity cover. But my view on that is that they're not a public authority, and therefore there's no claim there. But I don't think that's necessarily going to be an issue for any dental practices, because in reality, you've got the CQC.
Yeah, so, exactly. You can rely on that instruction from the CQC to make the claim.
I mean, and it will be interesting to see what insurers do, because obviously they're going to look for any reason not to pay out. Their insurance companies. The fact that the CQC, in response to what we're doing, has said, well, actually, we never told you to close. It will be interesting to see what the insurance companies make of that, and whether they do in fact accept that, or whether they say, in their view, is no, you did clearly tell them to close, because that might be very helpful for all of us, or those people who haven't got cover who are in the CQC challenge. That might be very helpful as a point of fact moving forward. Laura, one question that's popped up a few times is, what about the effect that the restrictions that have been imposed by or the guidance by the NHS, or what have you, the way in which the SOPs are being introduced, in particular the fallow time issue, and the fact that when dental practices were eventually able to reopen, they were obviously reopened to a much reduced capacity than they were before the pandemic. And also some delay to reopening. So two questions here: some delay to reopening because of the difficulty in some practices being able to get things back up and running with PPE and so on. Would that have an impact on what can be claimed?
The first part in relation to, the first part was in relation to the restrictions for fallow time and things like that. Unfortunately, I think that that's going to be difficult, because it has to be an inability to use, not an interference or a hindrance. The Supreme Court very much used those words. So the fact that unfortunately you have less footfall because people have been told to stay at home, the Supreme Court were very much, no, that's not an inability to use. So I think based on that, dental practices are going to struggle to say, well, we had to have more fallow time, so that is an ability to use. I think based on the Supreme Court decision, that's just an interference or a hindrance. So I think it will only be up to the point that you were able to open. In terms of sourcing PPE, I mean, if you weren't open, I think you could probably still claim, because you were still off the back of the instruction to stay closed. So I think you're all right with that.
By virtue of the fact that dental practices were closed so sort of quickly and brutally, it put you at the back of the queue for PPE. So the effect, it's all part of the effect of the original direction, it would seem. In another question that has come up is concerns that, and I think it's probably with brokers have been refusing to put a claim in regardless of the outcome. They've simply said, I think someone has made the point that their, I think Wesleyan, didn't even let them make a claim with cover. They've acted like a doorman. So when you've got people who are, or brokers who are saying, no, we're not going to put a claim in, what would you advise that people do there?
So, well, firstly, have you gone back to the brokers now, bearing in mind the Supreme Court judgment? Because obviously the Supreme Court judgment has very much gone in favour. So I think that the brokers shouldn't be sort of stopping these claims, bearing in mind this judgment. If not, find out who the underwriter is and go directly to the insurers, because they're the ones that are insuring this policy. They're the ones who you have the contract with, not the broker.
Great. Just to reassure some, there's been a lot of Aviva questions. I see someone's actually put on that Aviva has begun to pay out. So hopefully those of you with Aviva policies may get some luck.
I think it depends on the wording. You have to be careful, because I think I have seen an Aviva policy that has a list and they've said that they're not paying out because it's a without SARS.
So that's a very good point, actually, Laura. So
you have to depend on the policy wording.
Right. So it's not just company wide. There are different policies within each company. Is that right?
Yeah.
Okay. Someone has asked the question, is there a rebuttal against the, and quote, manifesting itself at the premises, which seems to be a quote from the RSA policy. So is there a way of arguing against, if you haven't had a case of COVID within the practice, it hasn't manifested it within the practice or within the premises, is there any way of dealing with that or arguing against that?
Unless you've got unless you've got the also cover that says within the practice or within a 25-mile radius. Unfortunately, if it's limited down to premises, and that's the Lloyd and White policy that the BDA have, they are the ones that say it has to be at the premises. And so unfortunately, unless you can show at the premises, you won't have a claim, I'm afraid. Yeah. And like I say, that's the policy, that's the problem with the BDA one.
Yeah. Someone's asked, can we help draft letters to challenge insurers? Yes, definitely. But of course, be aware that those are costs that you may not get back if unsuccessful or successful. So just bear that in mind. The question then is the broker our agent, as in, is the broker acting to the benefit of the practice as opposed to the insurance company?
Well, I suppose it depends on what your contract you've got with the broker. Yeah. The broker's just there to sell these policies. Your contract is with the insurer. So, because I have seen some people come to us because they're concerned about what the broker said to them in terms of selling these policies. Now, that is a separate question as to whether or not you've got a claim under it. That's a question as to whether the broker, what duties they owe you and whether they've missold you anything.
Which leads very nicely on to another question. Can we claim against our brokers, and particularly Lloyd and White, for recommending inadequate policies? Do they owe them a duty of care, Laura? I'm sorry to pin this. Do you think this is a possibility?
I think that the difficulty with that is it's, well, what were you asking for? And this is, you know, manifestation at the time. Who could have ever foreseen this? It will depend on what you have, your communication with the broker, what you've had with them and what expectations you've had, I think. Yeah. I think that might be quite difficult to say. Oh, I was expecting a policy to cover me for pandemics.
Yeah, I mean, it's quite a stretch to the sort of duty of care owed, and whether they could have foreseen something like this happening. Yeah. But it's, you know, it's maybe certainly something to be looking at, and it may be something that is worth taking up with the BDA, because of course they're well aware that this is an issue for their members, and that presumably they will have concerns about, or will have some idea about what they negotiated or what they told Lloyd and White was the requirements for their members. So I hope that the CQC will be taking this up. Sorry, the CQC, the BDA, excuse me. I've got a lot of questions about how do we join up to the CQC CQC challenge. There is a lot of information on our website about that, but what I'm going to do is just type in now an email address, and it's lawyers@jfhlaw.co.uk. That's lawyers@jfhlaw.co.uk. If you email that email address and just express interest in the CQC challenge, then Henrietta, who's been dealing with all of the administration of the case, will get back to you, will give you all the details that you need in respect of that. Again, this isn't so much, I'm not trying to sort of push the CQC case here. I really would encourage anyone who can make a claim under BII to do that first. But yes, do get in touch with us. It's lawyers at JFH Law, and that's coming up on the chat box now. And that is the best place to contact us with all the information that you need about that. I'm just trying to see if we have any other specific questions that we can answer at the moment. I'm just aware that it's coming up to, but it is 8:30 now. As I say, what we will do is put this webinar, the recording of this webinar, on our website over the next few days. If you do have any questions, email the lawyers at JFH Law website email address, and we will do our best to answer those in respect to the BII or in respect of the CQC challenge. And we will answer any questions that we'll go through here, answer any questions that